Alabama to remain in place. This is overturning a ruling from a lower district court. Here to discuss the case of Merrill versus Milligan is Talking Point's legal analyst Spencer Kweskin. Spencer.
Thanks, Chillicase. In order to understand this case, we first need to look at the Voting Rights Act of 1965 and the Constitution and what they have to say. In 1965, President Lyndon B. Johnson signed the Voting Rights Act during the height of the Civil Rights Movement. The act prohibited racial discrimination in voting. Under Article 1, Section 4 of the Constitution, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislator thereof, but the Congress may at any time by law make or alter such regulations. Additionally, the 15th Amendment states, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude, and the Congress shall have the power to enforce this article by appropriate legislation. After the 2020 census, Alabama drew a new congressional district map, which put a sizable proportion of black voters into one district. Black people make up a fourth of the voting population in Alabama. It would only be the majority in one district. A three-judge panel, with 2 Trump appointees and 1 Clinton appointee, found that the voting power of blacks would be diluted unconstitutionally, and told Alabama to redraw the map to give blacks 2 districts. But Alabama filed for an emergency injunction, and the Supreme Court agreed 5-4. When the Supreme Court normally hears cases, the previous lower court ruling stands while the case is being heard. However, when this emergency injunction was granted, the lower court decision was stayed. In this case, it allows the electoral map to remain in place for, at minimum, the upcoming midterms. Kavanaugh, writing a concurrence, stated that the federal district courts should not enjoin state laws in the period close to an election, and federal appellate courts like the Supreme Court should stay injunctions when lower courts contravene that principle. Now, the most interesting thing of note about this case is Roberts joining the 3 liberals in dissent. Now, Roberts has been historically against the Voting Rights Act, ruling against the 5th section in Shelby County v. Holder with a 5-4 decision. With a 5-4 decision in this case, this emergency ruling could spell bad news for the remainder of the Voting Rights Act and Democrats' future voting rights bills in Congress.